I think most people assume when they hire a lawyer that they're going to end up in court at a hearing or a trial, and that's a natural assumption because that's I tell people that's my Disney World. I go to the courthouse to have fun. Not everybody does. I don't even think the judges have fun when they're there. But for us as trial attorneys, it's good that a client feels that way. I think a healthy sense of the unknown and a healthy sense of nervousness is helpful. It's helpful that they are present and aware of where they are in life and what they're doing, and that it's real.
No, I agree with that. I think that the clients that aren't concerned, aren't worried, are the ones that aren't helpful when getting ready for cases because they so often don't realize that they're an integral part of their case. It's like, yeah, the attorney, the paralegal are crucial, but the client actually being helpful and participating and prepping for a hearing is very important, and them having some amount of concern to prepare is very important in getting the outcome you want.
People have a fear of speaking in public. I think everybody does. Even the best lawyer they will tell you. There's a lawyer who I've known for a long time in Columbia, South Carolina, who says the day he doesn't get nervous to go to court's the day he quits. And we, in the type of law we do, specifically in South Carolina, there are not a lot of chances until the trial for a client to have to speak in court. The lawyer gets to do it. I tell them it's a lot like going to Hogwarts, where there's going to be a lot of magical words said and some things are going to happen, and I'll explain it to them later. But the only time they're really going to have to speak is if we go to trial. And my mentor, the guy who taught me how to practice law, told me any lawyer can try a case, but a good lawyer can settle a case. And we work very hard to keep people from having to testify. If the lawyers do their job and go into trial, and the client has to be a witness in the witness box, particularly in family law, I think the families are going to be farther apart than they were going into it, because it's our job to advocate for them and only them. We represent their best interest and nobody else's best interest. And so our job will be to sling as much muck as we can to help prove their case. But we prepare them for that if and when we have to go to trial, and we prepare them for that from day one, even though they may never have to utter a word in court.
Yeah, it's amazing how once we start getting ready to prepare them, their willingness to settle sometimes might increase, and we also start digging into all of the potential issues that are going to come up on both sides, and it leads to us being able to settle these cases because they realize they don't want to take the risk or take the chance on something that might not take a turn that's in their favor.
Sometimes people just got to realize when they go to Disney World and see Space Mountain, they don't want to get on the ride.
Yeah, that's true. That's so true. I mean, because we've had that where we get ready for depositions or something like that, and we turn our deposition into a settlement conference because nobody wants to actually have to do a deposition, and cases get resolved.
Explaining the financial costs of going to trial versus settlement, a lot of times that is discussed and explained during the mediation of a case. So in South Carolina family court, most cases, I would say 95% of the cases that are filed in family court are subject to mandatory mediation. So at some point, you will be in a room with your lawyer and a mediator trying to reach a settlement. And my father's a very practical person. He grew up in Appalachia, so I grew up with a lot of practical wit and wisdom, and I approach my cases like that and my discussions with my clients like that as well. And so if we have, let's say, a teenager client or a teenager child involved in the case, someone who's going to go to college soon, we can explain to them that you could go to trial for 5 days or you could pay for a year of college tuition. And that reality, the cost of going to court, I think is something that everybody should understand at some point because it's not free. There's a financial cost to it. There's also the emotional cost to it, but the financial cost is a reality. And it helps people realize that they would rather spend their money in places other than going to court and trying to have their day.
Yeah, because that's a common conversation that we have to have oftentimes multiple times just to make sure the client fully understands the decision that they're making when it comes to the route they're going with their case. Because you can do simple math. You can do addition to calculate how much an attorney is going to cost to handle a mediation, handle various hearings, going to trial, prepping for trial. And that's simple math that we can calculate and show them how much that's potentially going to cost. And then if they see how much they're fighting over, there might not be anything worth winning at the end of the day. So that's an important conversation where, and at the end of the day, they want to go to trial and they want to fight for something, because sometimes it's not just financial in nature. They can make an informed decision, and that's the decision they can make.
When my clients come in, from the initial meeting forward, we are preparing for trial whether or not we will go to trial. Because for us to be prepared for trial means we know the case and we can see a practical resolution for them or solution for them or their family, where we might have a blind spot if we just hadn't prepared, if we just got ready for each thing piece by piece. Every part of the family law or family court procedure is preparing for trial. Your temporary hearing is a small taste of what trial would be like, and it's a brief glimpse for the court and for the clients into what is to come, and it gives us temporary rules to live by until we settle it. But that aspect of getting ready for that temporary hearing means that you need to sit down and have a theme and a motif and be able to tell your client's story from day one. And we both will ask a client in initial meetings, if we're here from a year from now, what have we accomplished? And knowing that, where we want to be and how we're going to prepare to be there helps us reach a settlement, because we can know what's our ceiling, what's our floor, what's our walk-away point. And you won't know that unless you do the hard, heavy work.
Yeah, and for our clients, sometimes it's our client that's the one that needs to really see that this is about to go to trial, and they're going to have to make some hard decisions, and it might go well for them, it might not go well for them, but oftentimes it's also the other side, and you just don't know who's got the case that has more to lose if it actually goes to trial. And oftentimes the closer it gets, they're going to have a real decision point where they're going to have to decide, is it worth the risk, or is a settlement going to be in my best interest, in most cases in my child's best interest? Because oftentimes they're having to make decisions that are going to affect their children for the rest of their lives as wards of these parents. I mean, they're going to have that decision to make, and they might not like the outcome.
Right. And so I'll circle back and have a little bit of story time. So the real trick of preparing for trial is to be able to expect the unexpected and be able to deal with it in the moment and not get flustered. Because for a lawyer trying a case, it's a bit like being a producer and director of a play, where you're going to have to cast the actors, write the story, and put the production on all at once. And there's a lot of moving parts, and it requires a lot of you. And so there's a lawyer I grew up learning from in Columbia who would tell this story that he had this kindly old woman, I want you to picture like a grandma type character, who had a husband who they'd been married for a very long time, and he engaged in a relationship outside the marriage, and that really broke her heart, and they were going through the divorce. And they weren't able to settle it, and they had to go to trial. And so my mentor prepared her for weeks of what it was going to be like in trial. They gave her examples of what direct examination would be and how cross-examination would be, and he felt really good about how prepared she was to go to trial. So they go to the courthouse on day one of the trial. He puts her in the stand. Judge says, Mr. Smith, call your case. You're going to call the case. I call Miss Doe up to the stand. So Miss Doe goes up to the stand. And he said, all right. Judge says, Mr. Smith, you ready? I said, yes, sir, may it please the court. Ma'am, would you state your name for the record? And her response was, that man over there cheated on me. And she was a little bit more colorful language, but my mentor had to collect himself and be ready to deal with something like that. Now, he, told the court, begged the court's indulgence, which is a lawyer's way of saying I need a little bit of time to gather myself. He gathered himself, and after that she testified. But, the thought there is that even though they did all that work to prepare her, inside of her there was something she needed to say, and she needed the floor to say it. And once she got that out, everything was okay. And in our family court world, people do need to have a voice. They need to be able to express themselves, and us preparing them for trial will help them maybe discover that voice or find a way to get it through in an effective manner rather than just raw, pure, guttural emotion.
To that point, I mean, sometimes parties can resolve a case, but they want to have some cathartic moment where they're able to get something off their chest and feel like they can move on. And sometimes being able to provide that for them without having to take it all the way to trial can be helpful. I mean, I know we've had cases where there is a fault base and that someone's committed adultery, and being able to maybe have a complete agreement but then have a short bit of testimony regarding the adultery lets them get that off their chest. If that's what they really need, they can do that in a contained environment where they've resolved the entire case, but then they can get the divorce based on that fault-based ground to feel like they've been able to face their spouse and confront them in what they did,
Right.
and feel like that they can move on now.
Our job is really, as family court lawyers, is to help close loops of communication that may have been broken over time, but also to help just bring some closure to actions in a relationship or with children involved. Everybody needs the ability to that end to move on. They've got to have that closure and that ability to deal with it. And the clients we see that we don't see anymore, right, because we understand we're worse than the dentist. People will cross the street to avoid us because we're family court lawyers. And I get that. That's fine. But, the clients that we help and we don't ever hear from again are the ones who are able to use this process that's cathartic in nature of getting ready for trial that may result in a settlement, because they're able to close those loops of communication. They're able to make those expressions of emotion. They're able to be present in the moment and not time travel where they're either living in the past or living in the future. They're there with us, and we do the hard and heavy work, and we're able to bring some closure and move on.
Yeah, I mean, because so much of a case, as you say, we prepare for temporary hearings, like we're getting ready for trial at that point, and the issues that arise and are the cause of them filing an action in family court, oftentimes, because of the length of the case, can be resolved, and those communication issues can be resolved, which allow them to acknowledge the mistakes that either or both of them have made, but be willing to work on it, to work on being co-parents or what have you, and come to a resolution amicably rather than everything having to be contentious.